5 seconds to go. Start. It is appropriate to provide an inviolable right as a precious safeguard for the accused, a pre-battle protection under Section 227 CRPC. Though this provision is couched in negative, it obligated the court concerned to unfailing consider the record of the case and document submitted therewith, and also to hear the submissions of the accused and the prosecution in that behalf, to arrive at a conclusion as to whether or not sufficient ground for proceeding against the accused is available thereunder. Certainly, if the answer of such consideration is in the negative, the court is bound to discharge the accused and to record reasons therefor. The corollary is that the question of framing the charge would arise only in a case where the court upon such exercise satisfies itself about the prima facie case, revealing from the record of the case and the documents submitted therewith against the accused concerned. In short, it can be said in that view of the matter that the intention embedded is to ensure that an accused will be made to stand the ordeal of trial only if the record of the case and the documents submitted therewith discloses ground for proceeding against him. When that be so, in a case where an application is filed for discharge under Section 227 CRPC, it is an irrecusable duty and obligation of the court to apply its mind and answer to it regarding the existence of or otherwise of ground for proceeding against the accused by confining such consideration based only on the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in that behalf, to wit, such conclusion on existence or otherwise of ground to proceed against the accused concerned should not be and could not be based on mere suppositions or suspicions or conjectures, especially not founded upon material available before the court. We are not oblivious of the fact that normally the court is to record his reasons only for discharging an accused at the stage of Section 227 CRPC. However, when an application for discharge is filed under Section 227 CRPC, the court concerned is bound to disclose the reasons, though not in detail, for finding sufficient ground for rejecting the application, or in other words, for finding prima facie case, as it will enable the superior court to examine the challenge against the order of rejection. By applying the laws enunciated and the principles laid, we will proceed to consider the case on hand. In the final report filed in FIR number 371 of 1993, viz. In the custodial death case, the afore extracted portion from it revealed that the essence of the accusation is commission of custodial death owing to the torture to which Ram Kishore was subjected to from 17th July 1993 to 23rd July 1993. It reveals that going by the same, he was illegally kept in the police station by accused numbers 1 and 2. Stop.